Good afternoon, Judge Kollapen.
Good afternoon, Acting Chief Justice, and thank you.
Welcome and thank you for availing yourself for this session of interviews. As you know, the session has come about as a result of an order of court that the Commission should do these interviews afresh. So we are grateful that you have availed yourself again. Thank you. Let us start. I see that you completed your BProc degree in 1978 and your LLB in 1980, both at Wits. Is that correct?
That's correct, Acting Chief Justice. I started my BProc at the University of Durban, Westville,
Yes.
and then was able to transition and complete it at Wits. Yes.
Yes, okay, all right. And then you went into private practice after doing your articles.
That's correct. I started practicing on my own in a small one-person firm and then joined a partnership, and that was in the early 80s.
Yes.
And much of the work then was really involved the struggle of ordinary people against the might of the state, and one found oneself doing a lot of work in defense of people who were charged with all kinds of offenses, public violence, people in
Yes,
conflict. with the state.
just hang on one second,
Yes.
Judge Kollapen. Let's just. Okay, all right. Yes, you
Yes,
may complete your answer.
And that was largely the nature of the practice. I also was the correspondent in Pretoria for Mrs. Priscilla Jana and Associates. And Mrs. Jana's her practice was largely devoted to public interest work, and I would do much of the Pretoria works. So that just immersed one into that area of work. It was interesting that I also had my practice in Marabastad, and Marabastad is where I was born. It was where people were consigned to be forgotten about, and it was a resilient community. And despite the poverty and the oppression, there was a sense that people would overcome. And I came from a very working class family. My father was a waiter, my mother was a seamstress, but they instilled in one a sense of value. My mum was quite political. She was, I would say, fiercely political. She went to jail twice at the age of 19. She marched in 1956.
And the period of your practice was about 10, 11 years, is that right?
Yes, it was about 11 years until I joined the Lawyers for Human Rights in the early 90s.
Yes. And you were with the Lawyers for Human Rights for something like, what, 4 years?
About 4 years until the end of 1996. I was appointed in late 1996 by President Mandela to serve on the South African Human Rights Commission. But I took up that post in January of 1997 on a full-time basis.
Commission for 13 years.
For 13 years until September of 2009.
Yes.
And I served.
And 7 of those years you were the chairperson.
That's correct. Professor Bani Pichana was the original chairperson, and then Mrs. Shirley Mabusela took over from him for a short time when I was her deputy, and then in 2002 I was appointed as chair and served until the end of my term in 2009, September.
Yes. And from the Human Rights Commission, you started acting in the High Court, and ultimately you were appointed in the High Court as a judge in 2011.
That's correct, Acting Chief Justice. I started acting in January 2010, was appointed in mid-2011, and have been serving there since then. Yes.
Yes. So would it be correct to say your entire practice was human rights law practice?
Not entirely. In a sense, when one lives in a community, substantial amount. Predominantly, but you would deal with the ordinary problems of the community: criminal work, matrimonial work, contracts. It was a mixed bag when you're a one-person practice. Yes.
Yeah. And you have been a judge in the High Court from 2011 up to now. Would that be 10 years?
That's correct. I think I'm probably now in my 11th year.
You are now on your 11th year.
Yes.
And you have acted in the Land Claims Court?
Yes, I acted in the Land Claims Court for 2 terms and then in the Constitutional Court for 2 terms as well.
Yes. And how did you find acting in the Constitutional Court, and how did you find acting in the Land Claims Court?
I enjoyed both experiences thoroughly. In the Land Claims Court, one was exposed to, well, the legal dimensions of an issue that is cardinal and germane to the destiny of ordinary people. And it's the question of land and the question of people's entitlement to the land and their return to the land. And beyond the law and the limitations of the law, one was able to also imbibe, in a sense, the deep sense of attachment people feel to the land. It's just not as a commercial entity, but as a place that signifies their whole history, their legacy, their relationship with their ancestors. And it struck me when I walked on a farm just outside Heidelberg in the context of a land claim, when the son of the family, and him and I walked for a while. You would walk for kilometers because you would do the markings and the photographs would be taken of the extent of the land. That was part of the preparation for the hearing, and how he articulated in the presence of the farmer the family sense of attachment. And that was perhaps one of the more important conversations that I was able to witness in the context of my work there. Because that conversation led to the resolution of that matter, in the sense that I think the farmer was able to understand this was not about a community wanting to grab my land. This was people who had a legitimate right to this land for a variety of reasons. And that understanding was able to resolve the matter. So I think that experience helped me considerably, acting Chief Justice, in both respects, both as a judge, but also as a South African, to understand the issue of land. And certainly in the Constitutional Court, I enjoyed myself there, because I imagine, even though I'm not a young boy anymore, the thought of any lawyer, the idea of serving in the highest court, would be something totally unimaginable in our lifetime. When we started practicing, it would not have been possible you would not be allowed to imagine that something like that could happen in your lifetime. And so when it happened, I would almost pinch myself every day to say, this is happening. And at a personal level, you dress up in the morning to go to court, and you'd look into the mirror behind your door, and you'd almost say, well, and you reflect and you think that you are enormously privileged to be able to serve your country in that capacity, given where our country had come from. But beyond that, I enjoyed the rigor of the work. I enjoyed the spirit of collegiality that existed there. And even as an acting judge, I think the willingness of other colleagues, of senior colleagues, to hear what you were saying. They may disagree with you, but they would be willing to hear what you said. And even if they disagreed with you, they would do so with due regard to your dignity. And they could be quite ruthless if they wished to, if you had produced something that was not of a quality that justified the status of that court. But I found that level of engagement to be quite affirming, and so it was a wonderful experience for the 2 terms that I served there.
And whether in the High Court or in the Constitutional Court, have you had a chance to deal with a number of matters where you have had to find legislation unconstitutional and provide an appropriate remedy?
Yes, I had to deal with the matter in the High Court. It was the matter of Rahobi and Rahobi. And it was an interesting matter, because I had to find sort of post-democratic legislation unconstitutional, and legislation that had a very good intention. It was the Upgrading of Land Act, and the idea was to upgrade forms of title that was less than ownership to full ownership, because of the past system that didn't accord full ownership. I'm not sure if you want me just to speak briefly about the case. I can do so.
Very briefly.
Okay, good. So Mrs. Rahobi lived in Winterveld, Mabopane area, and the certificate of occupation in respect of the home in which she lived was issued in the name of her brother. But she lived there all her life, and that was the only home she knew. He married and he acquired his own house. Later on, the then Bophuthatswana government upgraded the certificate of occupation to what was called a deed of grant. But the deed of grant was issued again in the name of the holder of the certificate of occupation, which was Mr. Rahobi. And then the democratic government decided to upgrade that to full ownership. But again, the full ownership would be upgraded in the name of the holder of the grant. So Mrs. Rahobi was excluded then from any claim to the property, and she would face possible eviction at the hands of her brother. And the fact that he'd acquired a property didn't matter. And it was challenged on the basis that it was firstly located historically. The original grant, which then carried a golden thread to the final ownership, was based really on a sexist, racist piece of legislation that excluded her from total consideration. And on that basis, I found it to be unconstitutional. I didn't say she had the right to the property, but at the very least, that when ownership of the property was being considered, she would have an entitlement to at least submit her claim. And Parliament should then fashion a process by which those competing claims could be considered and dealt with. And it was upheld by the Constitutional Court.
What sort of factors would you take into account if you were appointed to the Constitutional Court and the first case you had to deal with was a case where somebody wanted to have direct access to the Constitutional Court?
Acting Chief Justice, I would need to consider firstly that the design of our constitutional order is such that the Constitutional Court is the apex court, but you'd want to instill an idea of constitutionalism in all the courts. And therefore, the high courts and other courts play an important role in adjudicating constitutional matters. And therefore, the Constitutional Court should be careful it doesn't become the court of first and last instance. However, at the same time, there would be matters where the interest of justice and exceptional circumstances may exist that may warrant direct access. And there is a debate. I'm mindful that people suggest that there should be greater direct access, and some saying, no, one should ensure the jurisprudence that we seek to develop is one that's spread out evenly, and courts that sometimes have to deal with factual matters, for example, may be better placed to deal with those at the High Court level, where the Constitutional Court is not hearing evidence, they're not having to adjudicate factual disputes. And so those would be some of the factors one would take into account, mindful that it's a balance at the end of the day. Yes.
Yes, and did you get an opportunity when you were acting at the Constitutional Court to engage in reading in and reading down?
Not directly that I can recall, but then again, one is mindful in that process of the limitations that courts must accept that the constitutional framework imposes on us. That the role of Parliament is an important one. And in reading in, one does not do it to the extent that one usurps the legitimate role of Parliament. And it's a delicate balance to be struck. But sometimes the reading in of some words might mean that you deal with the mischief adequately, and there's no need for Parliament to deal with that. But I think in doing so, one must always be consciously aware of the demarcations of the roles of courts and of other organs of state. Certainly, the Constitutional Court is the apex court in our country. In the hierarchy of our Constitution, it's not the apex institution.
Thank you, Judge Kollapen. Any Minister?
Yeah, thank you very much, Acting CJ, and good morning, Judge Kollapen.
Morning, Minister.
Oh, afternoon, sorry.
Afternoon.
We have been sitting here since morning, so. My first question relates to the question you have given to the Acting DCG. I did not hear you mention the exceptional circumstances with regards to direct access.
I think I mentioned both, interest of justice and exceptional circumstances.
Oh, okay.
Yes.
Then the second question relates to one of the judgments you have delivered, AfriForum versus the University of Pretoria, on the language policy. There seems to be some divergence of opinion from the Concord on this matter, although not at the substantive level, but in the eyes of the public. They have recently delivered a judgment on UNISA, which is, when you read it, it does look like it was more on procedural grounds and not really on substantive grounds. But in the reporting to the public, it does look like it's on the substance of the matter. What could be your view when such judgments are delivered and summaries given, that the public understand them to be what they are supposed to be, and that the progressive stance that the University of Pretoria, the University of Free State, and I think Stellenbosch took, and some of them have been affirmed by our courts, should not be abandoned?
Thank you, Minister. As you point out, I penned the judgment in the University of Pretoria matter, and I upheld the language policy of the university, both on substantive grounds, but also on the procedural basis that I was satisfied that it satisfied the requirements in Section 29.2, that it was not reasonably practicable to offer other languages. As I understand the Concord judgment, it says that the University of South Africa did not discharge that obligation in demonstrating that it was reasonably practicable to do so, and therefore on procedural grounds it almost deferred the matter back to them. But I take your point that it might, in the eyes of the public, suggest that there are different approaches to a coherent language policy in higher education. And the Constitutional Court judgment doesn't muddy the waters, as it were. It deals with it precisely on the basis that it dealt with it. But it's in how the public understand the judgment that therein lies the potential for misunderstanding and mischief. And I think the summary is helpful, but it's helpful to a limited extent as well. Because, again, even media reading the summary could get it wrong and say that this is a setback. So I think the challenge that you raise is how does, well, I think it's at two levels. Firstly, how does the court affirm the substance of transformation in our language policy at higher institutions at one level, and be clear and unequivocal about that? Secondly, it's to say, well, having done so, how do we ensure that that transformation takes place in a manner that's procedurally fair and consistent with the Constitution? And if you fail on the second leg, it doesn't constitute a failure on the first leg, and it's maybe that messaging that doesn't come out as effectively as it should. And so I think maybe there's some scope for the court in terms of its own summaries to look at that. I think how media and others report on that is important. I think how government agencies, GCIS, Justice and Constitutional Development, report on that and share information with stakeholders is also important, because the principles around which the judgment is based, the transformative nature of the project we're in, is left intact, and there should be no doubt about that. If there's doubts about that, then it shouldn't happen, and it's unfortunate it does happen. And that's in the communication that the problem probably lies.
No, thank you. That was my first impression when I saw the media headline. It's only when I went through the judgment that I understood the procedural and the substantive aspect. But the general members of the public do not have the same kind of privilege that I might have, or some of them are not, as they might not be lawyers. They may not understand it even if they end up reading the judgment.
No, absolutely. And Minister, we must also take into account that how media report on it, some media might have a particular outcome and agenda they want to achieve. And they will put a particular spin on their reporting of the judgment to suggest that it's a substantive departure from other judgments, whereas it's not. Yeah.
Thank you, Acting CJ.
And thank you, Minister. The commissioners who are virtual, is there somebody who has a question there? There isn't, on those who are virtual, Commissioner JSC.
Then, when you apply to be a judge of the Constitutional Court, there are some few things that we must understand. What is your judicial philosophy? What do you regard as your judicial philosophy?
Thank you, Commissioner. As a starting point, for me, the law must be an instrument that achieves and advances justice. I'm quite mindful that the law can quite easily be used as a basis to maintain imbalances in society, as a manner to shield people from scrutiny, and the law can be a tool of power in the hands of some. So I'm mindful and not naive that this idea that the law must advance justice cannot be distorted. Having said so, I also think that one's concept of justice is one that comes from one's understanding of a society, one's experience in that society, one's ability, perhaps, Commissioner, to understand the heartbeat and the fears and the uncertainties and the hopes and expectations of the people you live with. Those are all things that shape the content of justice. It's not purely technical. And then the challenge is, when you get into a court, you carry that with you, but you function within the constraints that the system imposes on you. But it doesn't prevent you from bringing your own philosophy into your interpretation of the law and in the work you do. But it's sometimes a challenging and daunting task, because ultimately the law is not about what you want it to be. You have an opportunity to shape it, and ultimately it's the ability to deliver justice that will determine the legitimacy of the Constitution. And for many millions of people, they continue to live outside of the Constitution. It's still something far remote in their lives. And that's the challenge we have as a society.
Now, look, taking from, say, 96 up to now, would you say, has our courts developed a South African jurisprudence, or simple, have they developed an African jurisprudence built from our Constitution? And if you say that is so, would you, rather than simply to refer to customary law, that's not African law, because even others are the customs of other people. I'm interested to see or to hear from you. Have we managed to identify South Africa in terms of developing an African jurisprudence?
Well, I think we have paid some service to some of the values that reside deep in African society, but we haven't developed them to the extent that they form pillars of our legal system. And let me give you an example. So 1 year of this concept of Ubuntu. At the one level, it's come to mean anything and everything to everybody. Anything can be Ubuntu. And that's a distortion of Ubuntu. As I understand it, it's the recognition of our connectivity as human beings, of our personhood and our collective identity. Now, to what extent has that become part of our law of persons, for example, of our family law? I'm not sure it has, to the extent that we'd like it to, because I think there's much in that is rich and that needs to be expressed. In a judgment I wrote recently that dealt with the Interstate Succession Act, the father of a child who had died because of cerebral palsy had laid a claim to the estate of the child. And the grandmother of the child had also laid a claim to the estate together with the mother of the child. And in the judgment, I had the opportunity to reflect on the role of grandmothers in African society. And while I found in favor of the grandmother, I didn't do it purely on that basis. I did it on the basis that the Children's Act, in any case, properly read, would have excluded the father from being considered as a parent and therefore would be excluded from the Intestate Succession Act. But you might want to ask me a difficult question which I may not be able to answer now. You might want to say, Judge Kollapen, if the Children's Act didn't help you, what would you have done? Would you have found a basis in African law to have come to the same conclusion you did? And maybe we don't see that boldness. Thank you.
And thank you, Commissioner. Then Commissioner Madonsela.
Thank you, Acting Chief Justice, and good afternoon, Judge Kollapen.
Good afternoon, Commissioner.
Just remind me, from your own understanding, how much time have you still left to go as a judge in the country, given that your age is 64? And I'm not asking that on the basis that I have any objections to recommending people who are of a particular age. I just want to ascertain how much public service have you still got to give to the public by way of judicial service?
Okay, I think, as I understand it, I would probably have about 5.5 years to go. I would be 65 next year, May, and I would probably serve until 70. Is my understanding, yes.
Thank you.
Thank you, Commissioner Madonsela. Then Commissioner Dodovu.
Thank you very much, Deputy CJ. Good afternoon, Justice.
Good afternoon, Commissioner.
Lately in our country, there are two concepts that are used, and I want to test your understanding on those, as well as whether they do exist or not. The first one is judicial dictatorship, and the second one is judicial overreach. Contrast the two and share with us, in your own understanding, whether you see this in practical terms happening in our country.
Okay, I think in looking at the two concepts, one must frame it and locate it in at least a proper understanding as to what guides the approach to that question. And that's the principle of the separation of powers. The Constitution has clearly demarcated the role, authority, and scope of operation of the different arms of government. And the judiciary's role is not a lawmaking role, it's not a policy-making role. It's to adjudicate disputes. At the same time, it has the duty to declare law conduct that is inconsistent with the Constitution as such, and to fashion an effective remedy. And therein lies the challenge, because ultimately the judiciary, not because it has asked or it has taken it upon itself, but it has to exercise that role. And in exercising that role, it has to cast its eye over the conduct of the executive and the legislature. And sometimes it has to declare executive action to be unconstitutional. Sometimes it has to declare parliamentary conduct to be unconstitutional, but it does so because the Constitution requires it to do so. And so when it does so, it is not interfering in the arms but it's simply discharging its constitutional mandate. And there might be some arguments that in some cases maybe it goes too far. And if it does go so far, if it does go further than what it should, then that would be an example of judicial overreach. But I think by and large, our courts recognize and accept the limitations of the role that is entrusted to them by the Constitution. I don't certainly think that there's a case of judicial dictatorship. And if that is the perception, it's unfortunate because judges don't decide matters based on their individual idiosyncrasies. We take an oath of office, and while I have a judicial philosophy that's my own, I still function within a discipline that requires me to be loyal to the law, be loyal to the parameters of my power, and to be mindful of the role of other organs of state and to act accordingly. So I think those debates are useful, they're helpful, but I'd like to think, and I still believe that the judiciary continues to discharge and play an important role in our society. And when there's suggestions of judicial overreach, then by all means, let's debate those.
I don't dispute the fact that the judiciary plays that indispensable role. But this question of judicial dictatorship is emerging quite strongly. Do you think that is just a fallacy, something that doesn't exist, that people are just manufacturing something out of nothing?
Well, Commissioner, I think it raises the critical question that this role that the judiciary is required to play, and this role that it is playing, has always been a role that it was required to play and has played in the last 27 years. The reality, though, is that the judiciary is now being called upon more and more to deal with issues that are highly contested, issues of a deeply political nature. And I was thinking about it, Commissioner and Acting Chief Justice, this weekend, where politicians resolve a political dispute. They do so on terms and conditions and context that is entirely different from when a court adjudicates it. So two political leaders in the same party or in different parties who are embroiled in a political dispute might look at interests like, what does this mean for the electorate? What does this mean for compromise? What does this mean for winning votes in the future? And those factors would guide how they resolve that dispute. When that same dispute comes to a court, the court looks at different factors. It looks at the facts and it looks at the law. And the expectation of the parties as to what a court may do may be quite different from when that same dispute is being dealt with by. And therein lies the inevitable problem that when the court goes in a particular direction, there's going to be an inevitable suggestion that the courts are playing politics and getting involved in areas that they shouldn't get involved. I don't know how one avoids that charge, but that's not the case. When I sit as a judge, I don't go looking out for a case. It's a case that comes to me. And my judicial duty requires me to deal with that case.
Thank you very much. Thank you, Deputy CJ.
Thank you, Commissioner Dodovu. Then Commissioner Nyambi.
Thank you, DCJ. Afternoon, Judge Kollapen.
Good afternoon, Commissioner Nyambi.
If you can share with us what you think are the best attributes of a constitutional court judge, mainly 3 of those that you think you possess.
Thank you. I think the one, and probably the most important one, is to understand the Constitution, its location in our society, within its political, social, and economic context, and the expectations that that Constitution has created for the millions of our people. You need to understand that because ultimately that's what the constitutional project is about. Secondly, I think as a judge, you need to be humble and patient enough to listen, to allow yourself to be open to persuasion, to be able to persuade others, to interrogate honestly and openly the arguments that are presented to you. And then finally, to be able to work in a spirit of collegiality with other colleagues, to work efficiently, to deliver your judgments timeously, and to write judgments that do 2 things. One, that deal with the dispute and deal with it properly and decisively. But secondly, and this might be somewhat contentious, to try in your judgments to articulate a proper understanding of the Constitution, and this goes to the question of the minister, whether in writing judgments your constituency is only the parties, or whether you speak to the nation, and I think you do. You speak to academia, you speak to the profession, you speak to ordinary South Africans, and it's important for that to be part of the judgment writing process, because ultimately, if the Constitution must belong to everybody, then everybody must be able to understand what that court is saying. And with respect, you asked if I possess those qualities. I think I do, but I also subscribe to the philosophy that for me, life is an ongoing learning experience, and I've never stopped learning. So I learn all the time, and I continue to learn. But I don't think I need to still learn more to get there. But I'm saying that when I get there, it doesn't mean my learning stops, if you understand what I'm saying here.
No, I do. Thanks, Judge Kollapen. Thanks, DCJ.
Thank you. Commissioners who are virtual, is there anyone who has a question? No one has. Judge Kollapen, you said that your understanding is that you have 5 more years to go, is that correct?
About 5.5 acting Chief Justice, and this was an issue raised before on
Yes.
my earlier visits to
Yes.
this hallowed premises. Yeah.
Yes. And in 5.5 years, you would be 70?
Yes.
Yes. If the correct interpretation of the Constitution is that as long as you have not reached 75 and you have not finished 12 years, you have to go on beyond 70. Would you be prepared to go on?
On that interpretation, certainly I would, Deputy Chief Justice. I'm not saying that simply to allay people's concerns. I've been very fortunate to all my life do work that I've really enjoyed. I really enjoy the work I currently do. It fulfills and enriches me in every way possible. I still have good health. I'm still quite energetic. And so I'm not sure what will happen in 5 years' time, but I don't think in 5 years' time I'm going to have any less energy and any less love and passion for my country. And that's been the story of my life. Yeah.
Okay, thank you. I think there are no further questions. Oh, there is just one, Commissioner Zep.
Thank you, Chief Justice, and good afternoon, Judge Kollapen.
Good afternoon, Commissioner.
You know, from the question that was raised by Commissioner Dodo regarding the judicial dictatorship, and do you think, for instance, I mean, I know that what comes to mind is that the public still seems to misinterpret some of the judgments that come out of the court. Do you think something needs to be done by the Constitutional Court to strengthen the communication of the judgments to the public? And secondly, for me, I know that mediation can play a role, and you are one of the proponents of mediation. Do you think such matters can be actually be fast-tracked if we reintroduce mediation into the judgment?
Thank you. With regard to the first question, yes, I think, and in part I responded to Minister Lamola with regard to this question, that yes, communication can be better, and even sometimes the media summaries may speak to a limited audience. As the Minister indicated, if he read the media summary in the UNISA case, he would understand the procedural basis. But if a member of the public, if somebody living next to me read it, may well come to a different understanding of that. And so I think in that regard, it's communication at two levels, I think. The one is of the actual judgments, but the one is for people to understand the role of the courts in the constitutional architecture, because people might say, but hold on, 40 million people go to the polls to elect members of parliament. And so they carry a mandate from the people and they pass legislation based on that mandate. So isn't it unfair for 8 judges or 10 judges to set aside that legislation? That sounds undemocratic, but that needs to be explained, that it's part of the design, that Parliament must act in accordance with the Constitution, and if it doesn't, the court can set it aside. And it's not an instance of judicial dictatorship, but the courts exercising a role given to them by Parliament. So I think it's at the two levels, Commissioner, both conceptually, in terms of its framework and the architecture, and then in individual judgment. But even in the individual cases, I don't think the responsibility must be exclusively with the court. I think organs of state, and I spoke about GCIS and others, can play a role, and civil society can play a role in that regard. On the question of mediation, I think, and to some extent I should have mentioned this in relation to Commissioner Nyotesi's question, is that for a society that has prided itself in its ability to mediate almost an intractable political impasse, in 27 years, we've become a litigious society engaged in adversarial litigation, where we are constantly in conflict with each other. And we don't use and embrace mediation enough. So sometimes as a judge, you would push the parties into mediation, but that's not your role, because the parties can say to you, Judge, we've come here for you to adjudicate, and there must be a winner and there'll be a loser, and that's not your problem. So I agree with you, we need to find ways of embracing mediation in a much more substantive way. And the Law Commission, I think, may well be proposing that in family disputes, a matter should not come before a court for adjudication unless there's been an attempt to mediate, or unless the parties can provide a convincing explanation as to why mediation is not possible. I think we would be saving lots of judicial resources. I think we could even ask judges to be involved in mediation. So if I have to sit for 4 terms, I could be on the mediation role for 2 terms. Because aligned to your question is, where will the capacity come for mediation? So I think that there could be a resort to some judicial capacity. But aligned to that, Commissioner, you and I spoke 10 days ago at the launch of a mediation training program for lawyers and advocates in the country. And I think that's an important constituency to reach as well. Because with all due respect to them, and I'm not casting any accusation at them, Commissioner Mpofu, but lawyers may also contribute to this adversarial thing. You know, I know people who go to a lawyer in a family dispute, and the first thing they'll come back, they'll say, don't worry, we're going to sue him, and we're going to sue every cent that he has, and we'll take the clothes off his back. That's something a woman who's scorned loves to hear. And she said, that's my lawyer. But if you track the case, Acting Chief Justice, 12 months down the line, the case gets settled on a very different basis. Everybody's still intact. And I think getting the lawyers also to buy into mediation is important, because...
Yes. I'm sure you have made your point.
Thank you.
Judge
Thank you.
Kollapen. Thank you very much, Judge Kollapen. We have come to the end of the interview. Once again, thank you for availing yourself. You are now excused.
Thank you, Acting Chief Justice and the Commissioners, and thank you for the invitation and the opportunity, as well as the dignified manner in which the interview was conducted. I do appreciate that. Thank you. Thank you for your leadership here. Thank you.
Thank you. Thank you.